Every week, 800 million people interact with conversational AI. For a significant portion of those users, these platforms have become the primary tool they use to navigate a mental health crisis. This chart shows the scale of that usage according to OpenAI's own October 2025 data. Among their weekly active users, approximately 1.2 million people show indicators of suicidal planning or intent. To manage this, OpenAI describes a safety pipeline of detection, risk assessment, and crisis routing. But while the workflow mimics a hospital triage system, the company's documentation does not name a single licensed clinician responsible for overseeing these life-or-death decisions. Research is beginning to map the failures of this unsupervised design. A study from Brown University identified 15 specific ethical risks when large language models act as counselors, ranging from the use of deceptive empathy to the systematic mishandling of active crisis management. This gap between detection and accountability means that for millions of users, these platforms are functioning as public health interventions without the clinical oversight required to make them safe. In February 2026, the absence of an escalation path became a matter of federal litigation. 8 people died in a mass shooting at a secondary school in Tumbler Ridge, British Columbia. 8 months before the shooting, OpenAI's automated system flagged the shooter's account for gun violence planning. Internal records show a group of staffers debated alerting law enforcement, but they ultimately decided to simply ban the account. The shooter immediately created a second account and continued the activity. Because there was no closed loop to alert the authorities, the detection system failed to prevent the real-world violence it identified. Now, the victims' families have filed 7 federal lawsuits in San Francisco against OpenAI and Sam Altman, seeking over $1 billion in damages and a mandatory overhaul of the company's safety practices. The plaintiffs aren't arguing that the code failed. They are arguing that the negligence was the architectural choice to build a detection system with no legal or clinical requirement to report the danger. While OpenAI faces lawsuits over individual failures, other tech giants are facing state-led efforts to force a redesign of their entire product architecture. In Santa Fe, Phase 2 of State of New Mexico v. Meta Platforms is opening before Chief Judge Brian Beachside. Meta has already been found liable for 75,000 violations of the state's Unfair Practices Act. New Mexico is now asking the court to impose a sweeping injunction. This would include the appointment of a child safety monitor, funded by Meta, with the power to audit the company's recommendation systems. The order would force Meta to abandon its most effective engagement tools for minors. It demands a ban on infinite scroll and autoplay, a 90-hour monthly time cap, and the removal of like and share counts by default. Meta's response has been an ultimatum. The company threatened to withdraw Facebook, Instagram, and WhatsApp from the state of New Mexico entirely if the judge grants the order. By threatening to exit an entire state rather than comply, Meta is identifying which specific design choices are essential to its business model. But the pressure isn't only coming from hostile courtrooms. In state houses across the country, lawmakers are moving with surprising speed to write these safety requirements into law. In Iowa, the state legislature just passed the Conversational AI Safety Act, a bill that sets strict rules for how chatbots must interact with minors. The law mandates persistent disclosures that a user is talking to an AI, bans unpredictable rewards designed to keep children on the app, and requires a direct protocol for referring users to crisis services. The bill passed the Iowa Senate 48-0. It passed the House 95-0. In a deeply divided political environment, a chatbot safety bill achieved complete, unanimous consensus. From Santa Fe to Des Moines, design choices that were once left to internal corporate teams are becoming matters of legal compliance. These are no longer isolated legal battles. They are part of a national trend that is closing the gap between tech companies and the people affected by their products. More than 40 states are currently suing Meta over child safety. Every state attorney general in the country is watching the New Mexico trial, waiting for a model order they can cite in their own courts. At the same time, Iowa is joining states like California, Tennessee, and Oregon in passing proactive safety laws. For years, the tech industry has argued that state-by-state regulation creates an unmanageable patchwork, and that only a single, lenient federal law should apply. But the unanimous votes in Iowa and the mirrored lawsuits in dozens of other states suggest this isn't chaos, it's the emergence of a de facto national standard. The platforms can no longer rely on broad legal immunity or empty safety blog posts to manage their risks. When a product reaches tens of millions of people, its design becomes a matter of public safety. The legal standard for clinical accountability is being established in real time. From mandatory referral loops to engagement caps, the design of these platforms is being rewritten by the legal system rather than the companies themselves.